everybody. Hi, and welcome to this webinar on most common objections that independent practitioners face while speaking to a new client. And this is Abhyuday Agarwal from LawSikho, and we are doing this webinar at the special suggestion of one of our participants at an earlier webinar. Okay, so this is going to be, today's session is going to be on what are the most frequent objections that you face and how to deal with them. Okay, and I have prepared a presentation that I'm going to take you through, and we're going to have a very exciting conversation right now on this. So, sorry, this is the wrong slide. Okay. Now, so one of the participants in the webinar had asked me, I think last week, that can you specifically tell us how do we address each objection that clients ask? You know, these objections come at a very dangerous time. Usually when you've been, doing your work on social media, writing your articles, sometimes people ask you for a quote that's, can you please send me a quote? I'm looking at a transaction where somebody will invest in my company or acquire, let's say, a game that my company has made, and they want to purchase an asset, and I want you to help out with the documentation. I need you to help out with the trademark registration. Please give me a code for it. My trademark registration is being opposed. I need you to help me out there. I need help in having a contract with a software developer. I need help in standardizing the templates with the end users of my website. These kind of questions clients come to you with, and then they ask you for a quote. And before you give a quote, usually you have a conversation with the person who reached out to you, and after the conversation you send them a quote, right? And now by this time you've already invested some energy on the matter. You may have done some research, you may have had a conversation with the client, and you have also, according to your own understanding, provided value to the client. But what has magically happened is, or what has happened at this moment uh, is that the client, at the last moment after receiving the quote from you, questions your expertise or says, why should I pay you so much? So this is what the objections look like. I'm going to get to them, and these objections completely take us off guard, and it's a very distasteful feeling. It's a sad feeling that we get, right? And it's like a feeling of rejection. So let's look at the objection and what it really means. Okay, and read one objection with me at a time, and we want to understand this best. So your quote is too expensive. My budget is only X, which is usually a tiny percentage of your quote. It's not like they're asking a 10 or 20% discount. They want to literally kill your pricing offer. So they want a 50%, 70%, 80% discount. Okay, and maybe the client has a low budget. The client also hasn't understood how you can really add value. It's just something they're thinking that I may need some kind of legal service, but he has gone all the way and asked you for a quote. Okay, then another question they may ask is, what's your prior experience in this area? How many other clients have you served with such issues before? Now, this objection is a challenge or a question about your credibility. It depends how you take it. Okay, now the client follows this up with another question. If I am your first client on this, then why are you charging me so much? Okay, and it's not about why you charging me so much, why are you charging me anything at all. That's how the objection tends to land on our ears. Okay, the other objection, another lawyer has offered to do this for Y% of the fee. Okay, and this will again be 30%, 50%, or 40% of what your quote is. They will not name the other lawyer. So this is an unknown lawyer, okay, or some online service they are taking, which is going to do this for dirt cheap cost. Can you give me a better deal? Okay, so they're not even asking me to match it. They're saying, give me a better deal than that as well. Okay, now if you offer this price, you will end up doing this at a loss for yourself. You will end up hating yourself for this work. You will also probably not be able to deliver the best kind of value that you want to. For example, if there are new things that crop up, you'll be like, I'm hardly charging the client anything. I don't want to take care of all these headaches. And what will happen is, as a result, there's a high likelihood that the work output will also be worse. Okay, because you won't care enough about the client for a very simple reason. Client asks for a huge discount, and you will be compelled to consider that I should not lose the client, so I must offer some discount. So you'll offer the discount, and then you'll hate the idea of creating client delight. and you will do this work at a loss. Another objection: I don't need you to draft the whole contract. Can you please send me a template? I will customize the draft for my needs on my own. This means that the client is not willing to pay you. Actually, they may pay you some nominal amount for the template, or they will not even want to pay you for that. They want a template and they're trying their luck with it, and they want to know that, can you please just give me a template and I'll figure out the rest. Okay, the client really wants free service or as close to free as possible. The other one, when they hear your cost for a contract that you'll draft for them, is I will draft it from the template. Can you please review it? What will that cost? What are your review charges? Because you're saying your time is expensive, so I'll use my time to do it, and you tell me what is the cost of your review. Okay, again, this means that there's a subtle hint to reduce your cost, and not by a small percentage, basically knock off most of your cost. Okay, most of your fee. Now, other objection: I can find templates for free on the internet. Why are you charging me so much? You just have to key in the facts. Now, this is another objection, and it really means that the client is not very sophisticated or not very well aware of his or her legal needs and how legal services can help him here, and has no idea about the value that you will specifically add by working on this. Okay, has a very generic idea. Then another objection: you're a fresher with no prior experience. Why should I give you the work instead of going to a more established lawyer? Or, okay, if I have to pay so much, why should I not brief a law firm instead, or a big law firm instead? Okay, now this is a very aggressive objection. The client wants a discount but is asking for it more effectively, like pushing you further away by taking 2 steps backward and then questioning, why should I pay you in the first place? Because you've got no experience. Or I could get a big law firm to give me that quote. And it doesn't mean that the client really knows about what a big law firm will charge. Okay, now if you are unprepared, this can trigger in feelings of, yes, I'm not qualified, I don't have experience, I don't know how to do this, so why am I charging? Okay, and that will make you want to give away a huge portion of your fee. You'll just wipe it off and give a very big discount. Okay, or you may, if you're some other people may be willing to lose the client. Yeah, some lawyers will say, I don't want the client who talks to me like that. But either way, it's a loss, right? Maybe the client really needed some part of the service. Okay, so how do we figure that out? That's going to be a question we address in the next part of the webinar today itself. Right, the other objection: I cannot pay you so much for a single notice or contract or petition. Could you instead send me a retainer quote for all my legal work? So I'll pay you monthly X amount. They may say 10,000, 20,000, whatever. But can you send me or they will not quote this number. They will say that you send me the quote for it, but send me something where you'll take care of all my legal queries. Now, it might look to you that it might appear, or the client will give the picture that they have more legal work and this is good for you. But the problem is that the client needs only one thing and is not able to appreciate the value that you will provide. Okay, or the client cannot appreciate the urgency of what he needs. Okay, so they are saying that you do all my legal work, and for you also this is basically, it's confusing you because they don't have all legal work right now. They are not planning to give a retainer to someone, but it confuses you and makes you give a discount for the one piece of work that you're doing in the hope that you may get something else. Okay, or it's making you go into uncharted territory because you don't know what all this legal work is going to be. Okay, usually clients are very unclear about what this work is and they just want a discount. So this is another way of asking for a discount. Another objection: let me discuss internally and get back to you. What does this mean? The client disappears after that. Or my partner or team is not agreeing to the pricing. Please reduce the cost by X%. This is again an attempt to get a huge discount. And what has the client done? They have put in an unknown variable, a third party, whom you don't know, whom you can't speak to. And they are saying that this is the person who has all the power and they can only do this. They will only go ahead if you quote me this amount. Okay. Now understand what has happened. It has been your failure or the client's failure in explaining to the third party. There may be 20 other third parties, but if the client is convinced, then he or she should be able to bring them around, bring all his board members, investors, partners, everyone around, right? Now that's not happened, and the client is using the third party excuse to say that he's not able to pay that, and these third parties haven't agreed. Okay, and these third parties are not in your control. You've not spoken to them, so you won't know what to say. Now these can be very demoralizing as objections. So how do you deal with them? There are two ways people deal with this. People start reacting and they they are either some people will give a discount. Some lawyers will say, okay, fine, I will do it for a cheaper rate. Some lawyers will get angry and say that and let the client go, and also, may vent out some anger at the client. Other lawyers may try to convince the client by saying that consider this to be a one-time investment. It will solve all your legal problems. You will not get services without investing in them. Now, these are not persuasive enough and will lead to loss of the client. Whether you're angry or not doesn't matter, right? But what do you need to do? The question here is, what do you need to do to successfully secure the client, right? Maybe you work for 2 hours, so you will bill lesser, or maybe you work for 10 hours, then you will bill more. But the question is that, how do I identify what the client needs and get past this objection so that I convert more, right? Now, what we've done is we've done some research to, based on our past experiences, we've categorized client objections into specific buckets. And it is usually important for you to view, when they're saying something, asking you for discount, you have to view this from the bucket. Okay, what is the category of the objection that is there? If you practice looking at it that way, your conversion rates and your pricing strategy could improve. You may convert more clients, and you may be able to charge more for the services. At least per unit of effort, you will be able to charge more. It may take more explanation to the client, but that's not a problem, because whatever you charge for the services will more than cover up for it. Okay, now the question that the client may ask will be based on whatever. It could be based on past experiences, based on lack of knowledge, that lack of the client's own knowledge about his or her legal issues, lack of how the legal system functions, a lot of problems that the legal system has. They've seen movies where they've seen 20 years, 30 years of cases being dragged for 20, 30 years. They see that in the news every day. So there are some concerns that clients have had based on their past experiences and knowledge. How can I trust you? This is the most important question. And this is also like a very open-ended question, because if you knew something objective, then you could have explained, okay, that you can verify, like, for example, how can I trust that Amazon or ClearTrip is giving me the best value for a product? I have 20 other places I can check it at, right? I can check, or a flight ticket. I can check another flight booking service. I can check another player's website like Flipkart, or I could check maybe a Shopper's Stop website. So I'll come to know now what's the price. But here, this is very, very open-ended. So also, this is not so commoditized. It's difficult to say that all legal services are commoditizable, correct? So now then the question is that there are multiple layers at which the client needs to trust you. Okay, now I'm going to give you the examples to the layers. I'm going to take assistance of a document that I've prepared, okay, to give you, I'm going to shout out questions at you, and then you tell me how you understand those. So how can I trust you that you have identified the correct problem? Okay, that is one question. Then I've been writing this in an article. Let me just show it. Okay. How can I trust you has these. Does this lawyer understand the problem that I'm facing? Do you understand my problem? Okay, that's one big question. Second, how do I know that you have identified the correct issue? Okay, I may not know my problem fully. There may be hidden aspects about it. So how do I know that you have identified my problem correctly? Okay, and most of the times what happens is that before you get the mandate from the client, what will happen is that they will want to know, okay, that are there new sides of the issue that you are telling me? Are there new areas you can point out? Can you highlight some more issues that you're facing? So how do I know that you are identifying the correct problem? Are you competent to deliver what you're promising? Have you done this before, or is my matter going to be the first time that you face this situation? Am I your guinea pig? Okay, so the client wants to know that. Also, they want to know that have you delivered this earlier? Will you be reliable? So how do I know that you will not mess up something else that is already working? Maybe you give me a solution which creates another legal issue somewhere else, and I'm only going to know this years afterward. Maybe there's a fault in your contract, and I will only know 2 years later when there's a dispute. That's going to be a big problem, because by then I'd have already paid you and executed a contract and worked on it, and then a dispute will crop up and I'll realize, oh my god, I needed to have this clause and this lawyer did not include it. Will you be available to resolve my queries after I give you the mandate? Or will you be unavailable? Will you ignore my calls? Will you give me short answers? Will you tell me talk after 2 days? I'll speak to you after 2 or 3 days. How can I trust that your quote is a fair price for the services? Okay. How do I know that you're charging me the right amount? What if somebody else can do this for much lesser? What if you? How do I know that you're not overcharging me? Okay. Now the second issue that a client faces. So this is the bucket. Okay. Now try to look at everything from this bucket, and then I'll tell you how to deal with these situations. Have you identified the correct problem? Are so many steps really needed to solve the problem? Okay, so most of the times what happens is when you get a client, you may either say that only this one step is needed, but a lot of times lawyers will say, okay, you need to give this notice, then you need to give this petition, draft this petition, and then we go to court, and then I will charge you per hearing, and this will be the charge. Okay, now the client will be like, is there any other way to solve this? Can you take some step that helps me solve this out of court faster? Do I really need to take all these steps? Do I really need to send that notice and then do this and then take it to the hearing stage? So a lot of questions are there. Okay, now you will need to help the client in identification of real legal questions. What is the risks I face? And see, I may not be equipped to use the law as a client myself. Okay, I've read about it for sure. There's a lot of information available, but I don't always know that, which information can I trust and which information I cannot. But I need you to tell me that if this happens to this, if this happens to this. Nowadays, if you go to doctors also, earlier doctors used to diagnose your situation, uh, see the test, prescribe a few tests, they'll see, and then when the reports are there, they'll see the test reports and say, okay, you've got jaundice, have this is the prescription, these are the medicines to take for this long, and it's done. Okay, now, however, doctors will explain to you when they're giving you tests also that, okay, now these are your signals, these are your symptoms, you may have this or this, therefore I'm prescribing these tests. When these tests come out, consult me again. When the results are out, then they'll say these are the reasons you don't have this, but you have this. Okay, so they explain like that because our patient has a right to be informed, and similarly the client will also want you to help them out. Now this is a more open-ended exercise for a lawyer and a client because the problem may not be so simple to see, which means you will have to have more conversation with the client to understand this, but it's very important. It's more of an educative exercise, but it makes the client feel that he or she has power and control over the matter and that you're on his side, not against him. That's the most important part. The client can see that you're on his side. Okay, so I'll give you an example now. One more thing that is there here is that clients don't know their problem properly a lot of times. So they may say, I need a co-founders agreement, but they may actually need a shareholders agreement and an ESOP plan and two other things. Okay, a waiver letter. There may be various other documents, but they'll say X and they may need X plus Y plus Z, or they may say only A and they need B actually. So for example, sometimes a client will say that I have only 15,000 rupees budget, I need a shareholders agreement ASAP. And then you'll realize that it's very difficult to do a complex shareholders agreement in that amount. Okay, it will take you a lot of time. But when you talk to the client more, you'll realize that that the client will make do with a simple co-founders agreement, which may be delivered in that cost. Okay. Then the thing is that a client will sometimes come to you and say, I have these huge ambitious business plans. I want this service, this service, this service, this service. And then, but when you talk about the cost, they will not have any budget for that. So then you may need to help them with prioritization that, okay, let's do this first, then this, then this, then this. Okay. And if you have only budget for this month, this much, this month, this is what is the priority because your next business goal is this. Other things can be taken care of later. So let's go ahead with this. Okay. That's what a client needs you to help out with. The next thing, how will your solution effectively solve my problem? Because every lawyer they go to, some lawyers say the same thing. Some lawyers say like will suggest one action and then with some varieties. For example, there's a contract and there's a dispute on it. Okay, and now let's say that contract is between a shareholder and an investor who has invested in the company. Okay, now you could do many things there. Maybe some part of the securities that the investor took are debt. Now one lawyer may say, I will ensure you can do arbitration. Another lawyer will say that, okay, let's start arbitration. Let's explore if we can file an NCLT case for operation and mismanagement. If there are receivables due, then let's see if we can even try an insolvency resolution. Okay, and these could be ways in which we can have the company settle the dispute or agree to more favorable terms, and they may agree to a renegotiated agreement. Now you have to go step by step and help them see that how will the solution actually solve the problem. You might say this is the solution and you may believe that this will solve it, but how? Okay, that how is very important. So there are two aspects. You are educating the client on the problem first, which was in step 2, and in step 3 you are educating the client on the solution. Okay, and if this is not done, you will understand that if you send a fee quote with the list of services to be delivered, the client will not understand, because the client will be like, lawyers know best, but I know my budget the best, and therefore I can't go ahead. You don't want that, right? Then the fourth point is, how much work does it actually take at your end to deliver the solution? Okay, now I'm not talking about a lump sum cost or a hourly billing model. Okay, you need to have an estimate of the quantum of work that this will take. If you talk to somebody who's a coder, they will tell you that if you give me this project, this feature I have to add, this is going to take 100 man hours of work. Okay, one person at a senior level who will give 20 hours, one junior developer will take 50 hours, and another junior developer to check it or something like that. Okay, and then they'll give you a breakdown, and then they'll say that this is the cost that these people charge for every hour or per month. Okay, and that's the breakdown that explains what's needed. Now lawyers are not used to doing that. We either give a lump sum that, okay, this is the amount, or we say that we'll charge per hour. Now if you say that what the lump sum is, the lump sum may just look too big for the client, and the client may not be able to appreciate what are the steps, what are the services, what are the features that you're offering them. If you only give hourly billing, then it completely gives you full control of the pricing without the client having any say in it, which is a scary proposition for a client, given that they've heard bad things about how much lawyers can charge, right? And they're not very well informed about the legal system. So what you want to do is you want to say that this is the solution. A, B, C, D are the steps. This is my quantification of time. This is the kind of time I will need to take to deliver these. So maybe there will be 2 iterations. Once I will speak to you, and I will need to have 2 calls. So even if you're drafting a contract, trust me, the simplest contract you draft, other than an NDA, okay, other than a non-disclosure agreement, the simplest contracts that you draft will involve you to take at least 6 or 7 steps. You'll talk to the client, get the requirements in, prepare a first draft, show the client, review it, get it reviewed, then edit it, send it to the other side, have a negotiation, be there with the client on the negotiation, edit it, and then send the final draft, and then coordinate on signing. Okay, that is a good 7 steps. Now when a client is asking you for a lump sum quote, they're not thinking through all these steps. Neither are you, which is why it becomes very difficult. Sometimes you quote a good amount also, and you'll be like, okay, I didn't envisage all these new things coming up my way. So the important point here is to be able to visualize that these are the steps and this is the work it will take. Now lawyers are not able to do that usually because of an ad hoc approach to learning, because they don't know, they've not delivered this service before, they don't know the complexities that can arise. So forget, like they can't even say to one full stage. Okay, now that's where the problem arises, that the client cannot understand what is the effort you're putting in. If they were able to, then you could say, okay, I'm going to charge you 2,000, 3,000 per hour of work, and it's going to be taking 8 hours. So this is my cost. This is what my cost will be. Somebody quoting you less, check with them whether they will follow this process. And if they're not going to follow this process, you know that there's a difference in what value I will be providing. If you don't need that kind of value and you don't need me to follow that process where I give you a list of features, I give you 2 iterations, all of that, then I'll just give you a template. Then I will do it like for 1 hour of my cost. Do you want that service? Give the client an option. He'll understand that what you're offering is really very different, and he'll choose the plan that works best. Now, how it helps you is that you don't lose the client. You give the client a choice, and the client can choose the service that he or she values. It is highly likely that if you give the client a cheaper option and you can take away some of the features or the steps, it is still highly likely that the client will come and choose the more expensive option, because then he can appreciate that how this is adding more value to the client. So you can create a more expensive option with more steps, but this takes you to see the option, to visualize it, and to know the complexities that can arise. Now, this is the next one. Okay, earlier you were quantifying your time, your own time. This is here you're quantifying the value for the client. Okay, now it's subjective, right? If you've seen in economics, or the cost, this is the cost of production. This is the cost that you're charging for the service, for delivery. Okay, this is the value that the client is getting, the marginal utility, or whatever we may call it. This is a subjective level of satisfaction that the client is getting, but it is possible to quantify that by measuring the risk if things go wrong. Okay, by measuring that risk. Now this is something that people do not do. Like if I get a client who comes for a software development agreement to me, or a software as a services agreement, or any other contract, the first thing that's going to be, the question that's going to be there is, you will help the client understand that where these contracts have failed and why they have failed, and the few things that need to be taken care of if this has to work out for you, for the client. Okay, then you have to help the client in understanding that if he goes for a cheaper solution also, what are the open areas, because the cost is not going to be the cost of the agreement today. The cost is going to be the open areas in the documentation that are going to lead to dispute later. Okay, if I don't have the agreements in place tomorrow, an investor will say, okay, your relationship is not determined by contract, or there are very basic terms missing in the contract, so we want this risk to be eliminated. Okay, so you will need to enter into this properly again. Second, if there's a dispute, there is a risk that you've already paid tons of money to the software developer in developing a product which is piecemeal for you, or which fits what you needed at an earlier time, but now you need to get the changes made and you will not be able to get these fixed. Okay, because there is a hold up. The hold up means that there's a problem from the software developers and you both are in a dispute, and he's going to refuse to develop unless you agree to his terms. Okay, because there was a loose end in the agreement. Now that means that you're not losing, you might save 20,000 rupees or 30,000 rupees by paying me less, but that cost over there is going to be problematic, because you will have paying customers who are going to get an inferior product. You will be at the receiving end of dictatorial terms from your developer, even though you own the product, but you have no skills to get it removed, get an alternative developer immediately on the scene. Okay, so what is this going to be worth to you? This is going to be worth 2 lakhs, 3 lakhs, 5 lakhs. There will be many other things. There will be cost of delays. The developer will charge you X amount and then he delays the upgrade by 14 days. What's that going to cost you? So if you don't want all those things factored in your contract, no problem. But if you want this to be factored in your contract, then you're going to save 3-4 lakhs of costs just out of having a superior contract. And the cost between a cheap lawyer and an expensive lawyer is 30,000 rupees. So you want to save 5 lakhs in the next 1 year, or you want to save 30,000 right now. Okay, because that's the question right now. That framing helps a client in visualizing the value of your service. Okay, now I'm going to speak about how you can address these issues as an independent practitioner. Okay, so step one is building your credibility. Okay, so what will your credibility address? This part. How can I trust you? How do you trust people who are in a particular area? If you go to a doctor, you will go to a doctor in a famous hospital or who works there. If you ask somebody for advice, you will look at, has this person been doing this for a period of time or not, right? So you don't necessarily need a CV. You need to know the answer. You need to know the information. So if a client is seeing you work on his, 1 second, I'm going to take you to the slide. If a client has seen you or has read about your work for the past 2 months, and they've seen how deep you go into every issue and how well you explain the pain points that they face, okay, even when you are not dealing with them, meaning they've just read your content, okay, and they keep following you on social media, then they will be able to trust you much faster, much more. Okay, this is the initial trust, so they will not randomly shoot your proposals down. Okay, that is one. Now to an extent that will work, that will filter clients, that will make clients respect you. They will not be questioning the very basis of your codes, but that doesn't mean that that is enough. You will need to still justify the value you're adding, explain the time of the effort that it will take from your end, right? Now I'm going to, so those steps will have to be followed, But let's start with step one, which is building your own credibility. So, if you've been quoted by in a few newspapers, you've been mentioned in the news, you've been writing regularly, okay, you've been conducting training sessions for a similar audience as the client, then the client knows that you have been working on these issues. Then they don't want to know exactly how many deals you did like this earlier. Okay, then and they will not ask you also that how many such past matters have you worked on. They will just say, have you advised clients with these issues? And it is so much likely that you'd have dealt with these issues in the trainings, in the write-ups, there only. So that question also won't arise. They will just say, okay, your quote appears to be high, can you just explain what is the pricing and what is the how much time it will take, if you've not sent those steps. Okay, but the credibility they won't question, which takes you far ahead in the negotiation with clients and increases your chances of conversion. Now, the other thing is you need to understand the client's experience with lawyers in the past, and whatever you can say social conditioning they have about lawyers, whatever they have seen about the legal system, all of that. Okay, how do you understand that? Now, the thing is that as a lawyer, you will face 3, 4, 5 people saying this to you every day, and you may get fed up of dealing with this issue. But with the client, you will have to have the patience to listen, because they really want it heard, and for them it's the first time or the second time or the third time that they're giving work to a lawyer, and they don't want the same messy experience again that they have seen or they have personally witnessed. So you will have to have the patience to listen and acknowledge that this is their concern. You cannot afford to react. If you get angry, then it doesn't work, right? You may feel angry, but if you vent it out on the client, it will not work. And you want to let the client make an informed choice. How do you do that? You let them make an informed choice by quantifying your work. You let them make an informed choice by helping them identify what is important to them right now, what can be done later, and what is the risk they face if they don't solve it now properly. Okay, and then the choice is in their hands. So what are you doing? You are framing the choice for them. Okay, the client, the choice actually is not whether to give you the matter or not. That is what the client thinks. But when you are helping them make an informed choice, you are defining the choice for them by saying that if this is the business you're doing and this is what you want to, this is the deal you want, then these are the risks in the deal. If you don't address them now, this is what it could cost you later, because you're going to go ahead with business anyway. You're not going to stop engaging a software developer. At the most, you will hire a coder in house. In that case, you will have an employment or a consultancy agreement. That also you will need help with. So you are helping them frame the choice that these are your alternatives. This is the cost of getting it wrong. This is what is needed right now. Okay, and to solve it, this is what is needed. This is what it costs. The real choice is now, because once it is framed, if you do it accurately, then the client will understand that this is the real choice. It's not about whether I have to pay 30,000 or 50,000 to my lawyer. It is about what do I stand to lose and what do I stand to gain by having this done properly. Will I have full control over the other side, over this over what I am dealing with? As let's say if I am engaging somebody for developing a software, as the customer, as the client of that person, will I have full control over my software, because that's going to be deployed in my company. Okay, so that's important. And then you will also need to get better at understanding what the client needs and values most. So see, once you have the patience to listen and you are not getting angry, then you will have to get into the conversation and identify with the client what he needs and values most. It's not often what they say on the face of it that I need this. That doesn't mean they need this. Okay, so you can answer that question, but you have to work with them to identify what they really, really need. There are so many entrepreneurs who say, I want a co-founders agreement because I'm going to get investment and the investor has asked me this. And then you will realize that there are 5, 6 other things. There was a loan which was not recorded on the books. They haven't shown it properly. They want a document from the company acknowledging that, all of that, a lot of stuff is there. So you have to identify. So before you give a quote, first you have to work on what the client needs and values most. And then you have to say, okay, these are the few things that I needed. Okay, then only you can give a quote. But the client will ask you the quote in the first place because they want to cut down their risk. But you cannot afford to fall for it because it will take you through the wrong direction. You may be diagnosing the wrong problem if that happens. Okay, then what else can you do? You can highlight the importance of the problem. At this point, do not point out imaginary risks and do not blow the situation out of hand. This happens a lot of times, and then the client will feel that you, being an interested party, you're the lawyer, you're going to do the work for them, and you're going to charge for it, so you are blowing it up. That's what the client will feel, that you're overemphasizing the importance. You can't do that. So you have to only point out what you believe is the genuine risk and the genuine importance. Okay. Then you will need to implement a superior onboarding process that ensures that these activities are done reliably. So it may happen that, initially you may face failures at specific points in this whole system. But like sometime you may realize that when you were giving the client a choice, you could not frame it properly. You could not help the client in identifying what is at stake, how much will he stand to lose just to save a few thousand rupees in legal fees. What will he lose? You couldn't define that maybe. So matters may not come once in a while because of that, but that you will grow with that, like that you will fix in over a period of time. But the problem will be, how do you reliably do that in each situation? Okay, how do you keep engaging with implementing this as a standard process? Okay, so you will have to think of the steps in an onboarding process from the first inquiry till the delivery of the service. Okay, that's what an onboarding process needs. There will be more than one step. It is not give me a quote, you send a quote, or you make a call and send a quote. No, it will have more steps there. Okay, and we'll discuss these steps day after tomorrow, 7 to 10 p.m. I'm going to share the link with you of the workshop also, so that you can find it. Okay, the second thing is knowledge of the work. If you see here, the whole area, the center point of all the issues are, I can't trust the lawyer because lawyers do not know enough and they will overcharge me for what they have. Why have lawyers done that? A lot of times they've done that because they didn't have enough work, and therefore whatever work they had to charge the clients more to survive from there. Okay, and it didn't matter whether they knew how to perform the work or not. So now how do you fix that? You will have to objectively deal with that. You can't just say that the client's experience is wrong. So by having more knowledge of the work and practice, you can at least confirm that your conversations, your emails, your proposals, your quantification of time, all of that is going to demonstrate to the client that you know what you're doing. And if you don't know it, then the client will spot holes and often catch you out unguarded, and they will get the sense that you're not prepared. Okay, then practice. Now practice is where people get stuck. They're like, I will only practice when I get the work, so what's the point of learning the work? No, you will have to learn how to do the work, and you can practice in simulation mode. That will give you the confidence that you can do it. If you draft something 2, 3, 4 times, you will get confident about it. Okay, and if you learn in a structure and practice these things in a structure, then you will have the confidence that I can do it. And because you're already, the client is coming to you after you have built your credibility, they will not be questioning you on how many earlier matters you've done like this, because they will be very clear that you're the right person who understands the issues, because you've written on that and given them so much free value before they even came to you. Okay, free value is not what value you give on the conversation. Okay, it's about how long they have been in your system, or watching your work, reading your work, and engaging with it. That's the free value that I'm talking about, and they'll be like, you are the person who identifies this correctly. Okay, and then practice is important. Access to mentors and coaches. A lot of times lawyers are unable to aim big. Why? Because they don't know that lawyers are unable to aim big. Why? Because they don't know that if I get stuck, then is there someone who will help me out? Can I approach somebody who has more experience? I have done, let's say I've done general commercial agreements, but how do I do a banking finance contract, or how do I do a technology agreement, or how do I help out with a recovery plan? Those questions become a big problem. Okay, so if you don't have the assurance that you have access to mentors and coaches, then there is that feeling that you are not able to fully stretch out while talking to a client. Demonstration of superior value. Again, how will you solve the problem better than the competition? Giving a backward working of the time that it takes to get the work done. Okay, at least to a 5 levels higher than what anybody else can do. Okay, so not saying I need to do this petition, this petition, this petition, but how much time it takes and to what degree this will solve the problem for the client. Till there we need to go. Quantification of the client's risk if the job is shoddily done. You can even give, this is what I suggest in the workshop, and I'm going to deal with it a lot more. Those who are interested can register here. Asta, if you can share the link on chat, that'll be great. But and I'll deal with all your questions, okay, very soon. Now, quantification of the client's risk is one. I even say that if you want to go to a cheaper lawyer, feel free to. I'm going to give you 4 questions to ask the cheaper lawyer, okay, because I trust you to make the best decision for yourself, right? Whoever gives you the best service, you will take that. So I'm going to give you 4 questions or 3 questions to ask the lawyer. You ask these questions. If he has the answers to them, that means he knows his work and he'll do the work cheaply for he'll do good quality work. If he doesn't answer those, or he's not able to answer, or he postpones, or he says that I'll come back to you, that means that I am giving you more value. Now then it's for you to decide whether you want that more value, because you clearly understand the need and the benefits of it. And if you don't want that more value, you want a simplified cut paste template, I'll give you that for the budget that you have. Then the client will understand that this is what is the important part. Now what happens for most lawyers is that we feel bad in saying that I've done so much free work, now I have to even deal with this, that I have to give the questions to ask to the other lawyer for the client. But this really helps, okay? This really makes the client feel that you are actually acting in the client's interest and you're not out there to just get the matter. So it makes it very, very powerful. It makes the framing very powerful. I'll just show you the link now. We're going to do a lot more of this objection handling with mock conversations in the workshop. This is the workshop, okay? I'm going to paste the link. This is available at a very unique one-off price. It has never been offered at this price earlier of 100 rupees. So those who are interested may go ahead and sign up, and you will get access to, we will have mock conversations. We will have an exercise that will help you implement this process for your practice. We will also see how you can resolve your knowledge and practice gap, how you can access mentors and coaches, and how that can help you in increasing your practice and clientele. We will examine that as well. We will help you work on all of these areas. Okay, how to do a quantification, how to do a backward working of time. Okay, top 5 questions you can give a client if he wants a cheaper service. Okay, then now how do you address, I'm going to go further now. So now make sure that your content is reaching the client even if he or she does not give you work. This is the post. So what will happen after you've dealt with all of this? You may either get the work, then great, go ahead, or you may not get the work. The thing to know here is that if you don't get the work, doesn't mean that the game is over. Okay, the game is still on. It is really never over. And most of the time we think that it is over and we ignore the client. Okay, what you want to do is make sure that your content reaches the client even if he or she does not give you the mandate. Continue to write emails, have him on your newsletter. You can say no problem, stay on my news. You can subscribe to my newsletter for free updates. You anyway wanted a lot of free information. I keep sharing that regularly with my readers. Okay, share success stories and how you solved problems for a similar target audience. Don't ask for work over there. Okay, and because you've got a disclaimer on your website saying that I'm only going to send these to people who have voluntarily asked for all of this. That's the disclaimer, right? That I am not soliciting. You understand, you can go back right now. Only if you yourself want to know about this, then you come here. And people click that. Then only they're getting these success stories. So it's valid to do that. Okay. And even in that, don't ask for work. You just share the success stories. If a client is interested, they will say, I need some help. Can we schedule a call? Then another thing you should do always, okay, and this is also not soliciting, share information that may be of relevance to the client and something useful that you specifically created. Okay, for example, suppose you want to advise the client of the company on something around employment law. You can say that I have created a small so you can say that, okay, these are the code on the 4 labor codes dates for implementation. I have created some transition plan which big companies can use to implement this properly. Or you can say that this sector is now going to be regulated. This is the news saying that. So this may be useful for you. Okay. I'm working on a on a white paper that, or I'm working on a handbook that companies affected by this regulatory system can use. You can say something on personal data protection bill also. You can start writing to clients that, okay, currently whatever systems you were following, now if you were not already, now additional requirements under the personal data protection bill, once it's passed and notified, will be these. Have you prepared a plan? Okay, so you can keep sharing news, whatever may be of value, information that will be of value, new content you produced, all of that. Follow up and check once in a while what happened and what's the plan for the next stage of business. This is very important. Now, this is the, what can I say? This is like the main course. I mean, it will expand your horizons with the client. So always do this. Invite clients or potential clients or failed clients, whatever you call them, to the events and webinars that you conduct, always with full respect. Okay, trust me, they will come to you when they have their experiences and they realize that you were the best professional on this. They will come to you. Now here what happens is, why do we struggle to do this? Because of lack of knowledge about the legal work. We do the wrong diagnosis, we give the wrong solutions, and our advice is often unrelatable. We can't understand the client's problem, or we can't give new insights to the client on the problem. They value this a lot, okay, because this is a proof to the client that you understand the problem. So the client says X, you understand it and say, okay, X is the issue, but A, B, C are also issues. Because the client faces that problem, they will say, yeah, you're correct. Okay, now that creates a lot of trust in the moment. Okay, this you can have to create instantaneously. You have to be aware. Okay, if you lack the knowledge and you don't do this, this will not work. This effect only will not happen. Then our solutions sometimes are not detailed enough. We may not be able to quantify time. We may not be able to quantify the risk of the client. Then lack of opportunities to practice in performing the work also leads, like I said, you can practice in simulation mode, but if you don't have enough practice, then we have lack of confidence. In our conversations, we sound underconfident. What are we underconfident about? Our pricing, the kind of time it will take, how much value we will demonstrate over somebody who is giving a cheaper quote. What is our full delivery capacity in reality? You can appear confident, but it seeps through. Now, when you are speaking to a client over a prolonged period of time, they can see what is your actual level of confidence, and then your quantification of time can go haywire. How do you beat that? You say 15 hours, it takes 40 hours. Okay, you will want to charge more, and you will hate the idea of having to work for so little. So those, and the client will say, why aren't you giving it to me fast? And you will say, I did the wrong quantification. And the client will say, but I gave you all the facts beforehand. So these things become a big problem. Okay, so you are not able to handle objections to justify the value and create trust. Then lack of training and mentors is an issue, because you can't give services on new areas when clients need it. You have to stay put to low value services which you've already worked on as a junior to a senior litigator or in a law firm in the initial phases, and you can't stretch more. You will struggle to outsmart the competition or the pricing for big law firms, right? If you want to learn how to do this, get into new areas, have the onboarding process that I spoke about, have access to knowledge, training, mentors, okay, and full insights on what strategy to use to onboard clients, then you're most welcome and invited to the workshop that I was just talking about. Please go on this link and register right now. There is a refund policy also. You have to attend the workshop live and you must perform the exercise. And if after that you feel there's no value, there is a refund policy. You can claim your refund. Of course, it is to get your trust on it. And I am very clear that if you perform this work, you will find new insights and a new power in dealing with clients. Okay. Now I'm going to address some of the questions that came up. There are questions in the chat and the Q&A. Just running a little short on time. Effort differs from case to case. Anonymous attendee, yes, very much. How much time will you take to get the relief? Can I assure success if I go for litigation? You cannot assure success. So what you can say is that these are the 4 litigation routes I can take, and I want to take them in parallel to increase the pressure on the other side for an out-of-court settlement. So many litigations, so many arbitrations are settled out of court, and then a consent decree is passed based on or a consent award is passed based on the terms arrived at by the parties. But it is not settled just because it took time. It is the terms on which the settlement is passed is based on how well each party framed their litigation strategy, their pre-dispute strategy, their documentation, okay, and then the sites from which they attacked. That is going to lead to the chances of an early settlement and a favorable settlement. You want to highlight that, and then you want to say that this is not guaranteed. These are the unexpected things that can happen, but this is the most important thing that you need to do. And if you don't start relief or remedies in parallel, there will be a problem. Rakhi, this will be a slight change over that. It's an adaptation of Beat COVID, but I will be adding some new things. Rohit, if a lawyer is not ready to apprentice you and other lawyers are acting like dictator who don't want to see you. I didn't understand the question, Rohit. Please explain it further if you can. Because you're talking about how to deal with clients, so I didn't understand the lawyer question. Okay, now some more questions on chat and then we're going to head. Abhijit Sharma, which objection? Is it clear now which objections, how to handle those? Nidhi, why is it difficult to display credibility during COVID? During COVID, what I found was a tremendous opportunity for lawyers was the opportunity to be present in multiple courts through virtual hearings and to do way more meetings with clients than you could do earlier, because you can work remotely. You don't have to spend time traveling. All your trainings also could be all your trainings could be recorded on YouTube, put on your site or put on your video channel. There's so much more stuff you could do. It didn't matter what was the condition of your office or your car, which city you worked from. None of that mattered. Okay, so it's even better. The only thing is, because courts only took urgent matters for a long portion of the time, you may have had to provide non-litigation related services also. Okay, that's the only thing that had to be done. But credibility is your past, okay, what all you've been doing and you have done. So you can always jack it up. It has no connection with anything else. It has no connection with courts hearing matters. It has no connection with clients having the cash flow to pay you, none of that. Okay. Is my voice audible? Am I audible? Because Mr. Jaina is having some trouble. Rajesh, you can just go and register. It's $100 only. Okay, check on the group for master access. You may get access directly. Just check on the group. Nidhi, difficult to gain trust of local clients or those coming from rural areas. Okay, so every time the credibility building effort is of the same nature, the medium may be different. You may need to create videos in the vernacular language. You may need to simplify issues a lot more. That is it. Okay, Kshitija, that will depend on your syllabus at your curriculum in law school, but it's important to do internship sooner, as soon as possible. Yeah, Abhijit, which is a better pricing option? Abhijit, you need to quantify. Okay, so you need to say that this is what it will take. These are the per hourly charges, and I'm estimating this matter to be resolved in these many hours, and subsequent stages will be additional. So the client has a frame of operation. Otherwise, it's not clear. Kshitija, there are many CS, ICWA there in line along with lawyers on certain financial suits. How to cope up? Yeah, so lawyers always have an advantage as far as legal proceedings are concerned on how they frame the issue, how well they use legal arguments. But lawyers avoid looking at numbers, which I think you should not do, because you don't have to be very skilled with it. You need to just be able to understand and read the numbers. We have specific courses which can help you on that. But for now, I think what you should look at is, deal with these doubts in more. You can deal with these doubts in more depth at the workshop. We will address these questions there, so don't worry about it. Okay, is my audio clear? Are you able to follow me, Kshitija, Nidhi, all of you? Okay. Okay. Then Nishad, 100 rupees for the workshop. Rohit, yeah, do not, if you've been seeing my emails and webinars earlier, don't wait for lawyers to train you and then pay you for the job. Okay, take training from elsewhere. We help people with training. Come for the workshop. I'll explain to you how to figure out the training part, and then you can have access to lots of mentors. So what you need is a mentor who guides you on serving the client, but you need separate training. Otherwise, if you want to spend 10 years training under a lawyer, not having income, and then also hearing these issues from lawyers that I don't have work, so how should I train you? What do you know? Why should I train you? All of those problems will arise. Now, exactly the problem you're saying. Nobody is ready to train you. They're trying to run their practice. They don't have the time and patients at the moment to train you. So those problems are an issue. Okay, everybody, I'm going to log out now. This training is from 7 to 10 p.m. on Friday. Okay. And I'll also explain in the workshop how to ask for an advance on the fee when you go for the hourly option. All of that I will ask. I will explain how to do that. What stage to ask for an advance. Okay. So, all right, everybody, please share your feedback. And we're going to log out quickly. I'm going to stop broadcasting on YouTube. And thank you so much for attending. I hope your questions were answered. But if there are any other queries, feel free to write back to us. And I'd love to see you in the session on Friday. All right, everyone. So see you later. And at 9 p.m. there's another webinar which Raman